Afternoon, committee members. I have the honor of chairing the meeting this afternoon, and Ms. Childers, if you would start with roll call, thank you.
Representative Alamant, Representative Angelos, Representative Haroldson,
Here.
Representative Pendergraph,
Here.
Representative Sherwood,
Here.
Representative Smith,
Here.
Chairman Bear.
Here.
Madam Chairman, you have a quorum.
Thank you very much. So first up today, committee, we are discussing House Bill 130, Second Amendment Protection Act and amendments. Who do we have to present the bill? Please welcome, Representative. It's nice to see you.
Madam Chairman, I'm here today to present House Bill 130. It's a bill that we've probably somewhat familiar with. It's been around a little bit, but it basically takes our, it's referred to as a SAPA, or the Second Amendment Protection Act. And this basically just adds some additional things. Currently, there's a criminal provision. This is adding a civil position or a civil provision that allows for civil actions to be taken. It's very clear to me what this bill does, and it's very clear what it does not do. It basically insulates our law enforcement officers from ever being tasked to assist the federal government in violating our Second Amendment rights. Deals specifically to firearms, munitions, and accessories. And there's been some confusion about it. What it does not do is it does not prevent our law enforcement from assisting federal officers in the performance of their duties, so long as those duties are not violating our Second Amendment right in relation to firearms, munitions, or accessories. And this bill just basically adds that element. There's two provisions. It basically says that their policies, if they have a policy that tells or directs their officers to assist in that activity, they can be criminally held liable and they can be sued civilly. It also deals with sometimes the federal agents will come in, like ICE perhaps. They might come in and they have some ICE officers, but they need some of our guys to fill in. This doesn't prevent them from assisting as long as it isn't violating our Second Amendment rights. If it has nothing to do with the munitions, firearms, or accessories. And the one thing that's really clear, this requires our laws, Wyoming laws, to take precedence. That's what we're doing. We can't really tell the feds that they can't do stuff, but this is basically setting the stage that our guys cannot be drafted or coerced into helping enforce federal laws or regulations that should come down that address firearms, ammunition, or accessories. And so that's it pretty well in a nutshell. I would be here to answer any questions should you have them. And I do believe there is one friendly amendment that it's more an editorial correction, I believe, a technical correction. Okay. So I am aware of that, and that is something that I do support. It's a technical edit. This mirrors a bill that we had last year, and I didn't want to misrepresent it to everybody, but we found that there's a section that needs to be moved from one spot to another. So it's a technical error that actually was in the Senate file that we passed last year, but we had time to review it and we're able to correct that. So with that, I'll stand for any questions that you may have.
Thank you, committee. Are there any questions for the bringer? Representative Haroldson.
Thank you, Mrs. Chairwoman, and Representative Worf. Thanks for coming today. So as we're looking at this bill, obviously this is not a new bill to us. We've had this conversation before, had this conversation last year. Talk to me about House Bill 130 compared to Senate file from last year that went to the governor's desk. Can you talk about what are we seeing different? What does that look like?
Okay.
Talk about that, please.
And I appreciate that, Madam Chair. This mirrors Senate File 196, which is the bill that passed both chambers. If you'll recall, towards the end of last session, there was discussion about whether we wanted to use an extra day to hold us over. We would have had to stay over the weekend. One chamber voted for it and one did not. And our concern was we felt that this would be vetoed by the governor, and he did. As you know, when we adjourn, it goes from a 3-day window to a 14-day, and on the 14th day of our adjournment, he vetoed Senate File 196. And so I just asked LSO to resurrect it. And so this is the same bill. If you were to look at this in Senate File 196, they're the same. There's a couple, like I said, technical edits that LSO put in. There are some sections where it referred to act, and my LSO attorney said that we shouldn't refer to it as an act until it's passed. So she made corrections in that. And then, like I said, I do know, and I believe that Representative Haroldson has the amendment, but I'll let you talk about the amendment. But it is something that when we reviewed it, it is identical to what we passed, but the bill that we passed last year had that technical problem, and this paragraph needs to be moved. But I'll let Representative Haroldson bring that to the committee when he's ready. But that answered anybody's questions on the genesis of this.
Do you have a follow-up on that? Are you good? Are there other questions from the committee? If not, I have one. Could you help? So thank you for clarifying. This bill was vetoed last year by our chief executive. How have you addressed concerns that he had with the bill? And are there any proposed changes in this piece of legislation to remedy that?
Madam Chairman, no, this, you know, I really didn't look at it. I probably should have looked at what his rationale was for it. I felt like this has been beat long enough. It passed overwhelmingly in our chamber. It was 54-4, and there's 4 excused. And the Senate, I believe it was either 29-2 or it was 31-0. So, I mean, we had the votes to override a veto, but with us not being able to veto it or to override that veto because we'd adjourned. But I didn't look at it. I felt like, and I believe most of the people in both chambers felt like it had been adequately debated, that the concerns had been addressed. I know there's some concerns that have been raised. There's some concerns that continue to be raised, but most of those concerns that I've heard are unfounded. And that's why I said it's really simple. It's not as complicated as it would appear. But if you don't understand kind of the firearm laws and stuff, to me, this is really clear. It just says our law enforcement guys cannot help or assist any federal entity that comes here to violate our Second Amendment rights as Wyoming citizens. And it is specific. It says that Wyoming's laws are the laws that we want our guys to enforce, which includes protecting our Second Amendment. And this isn't a condemnation or criticism of our law enforcement entities that we have. I look at this is added protection, so that in the event we ever have an administration, and heaven forbid an executive director that doesn't see our Second Amendment rights as vital as we do today, at least we would have that on the books so that the citizens would have some recourse should that occur. I mean, nobody wants to see that happen here.
Committee, if there are no further questions, I think or do you have a question? If not, we'll move to public comment. Okay.
Thank you.
Welcome. Please introduce yourself for the committee.
Thank you, Madam Chair, members of the committee. My name is Aaron Dorr. I'm here on behalf of the members of Wyoming gun owners, and we are very much in support of House Bill 130. As everyone knows, this bill has been discussed a lot in this committee and in this body. This bill is going to do 4 or 5 things to enhance existing SAPA law. I'll mention those briefly and spend a little more time what the bill does not do once I get past the first part. The first thing this bill does is it adds civil penalties into the existing SAPA law on the books. That's on page 4, line 17 through page 5, line 15. This allows an impacted citizen to take the agency, not the individual officer, but the agency into civil court for a civil penalty should his rights be violated. It takes that, it puts the power in the hands of the person directly. On page 3, line 19 through 20, we clarify a current ambiguity in current SAPA law, and we make it very clear that we will not want to see Wyoming cops be used in a federal gun seizure task force. Right now, it is very unclear as to what they can and cannot do. As long as the money comes from the federal government, it would appear to allow for these federal gun seizure task forces to exist. This would stop that. Again, it's page 3, line 19 through 20. There's also some cleanup language on page 3, line 20 through 22, that makes it clear what Wyoming officers can and cannot do. Right now, it's just very ambiguous, and we've heard from law enforcement, can we do this? Can we not do this? And so on this section, it just says very clearly, shall not be enforcing any federal gun control laws, period. On page 4, line 9, we add the identification of peace officers from 7-2-101. The current law's penalty section only deals with public officers. And of course, as this committee knows, that means people like yourselves or the governor whose office comes from the Constitution. By adding peace officers, it makes it more consistent with the idea behind the bill. And finally, on page 6, line 5, all the way through page 7, line 5, we have a section that prohibits an officer from basically, if you have a Wyoming officer who then changes and he becomes a federal agent for a period of time, and he enforces federal gun laws, that would be a violation of SAPA if he was still operating under his Wyoming credentials, and then he wants to come back to that department and go back to his original position, that would be precluded. We're trying to find a way to make sure that we don't have officers who simply jump to a different agency to circumvent this legislation. That's again, page 6, line 5 through page 7, line 5. Madam Chair, more importantly, we've seen some sensational claims about what SAPA will do in this over the last 48 hours from various entities. I want to be very clear on these things. SAPA does not prevent Wyoming from receiving federal assistance to aid in the enforcement of the laws of Wyoming. It's right there on page 8, line 1 through 2. It's very clear. All assistance can be received by Wyoming to aid in the enforcement of the laws of Wyoming. That could mean money, that could mean personnel, that could mean databases, NICS, NIBIN, all the databases. It could be equipment, helicopters. Everything can be used by Wyoming to aid in the enforcement of Wyoming laws. We are not precluding assistance from the federal government. Again, it's page 8. Also on page 8, we make it very clear, this comes up a lot, we are not allowing in this legislation Wyoming cops to be civilly sued. This is asked a lot. It's on page 8, line 17 through 19. Only the agency who employs the officer or the subdivision who is the town subdivision could be civilly sued. No individual officers can be civilly sued under this House Bill 130. Also on page 8, line 13 through 15, it's very clear this does not prohibit the seizure of firearms and ammunition as a part of an investigation into a violation of Wyoming law. We're not saying Wyoming cops cannot seize firearms and ammo if they're investigating a violation of Wyoming law. That's very clearly spelled out. Again, it's on page 8. In fact, SAPA doesn't even stop Wyoming officers from aiding the federal government, even if firearms are involved in several key areas. If you look at page 7, line 16 through 21, it would make it very clear that even if firearms are involved in cases of felony narcotics crimes or felony persons crimes, if the feds ask for assistance, that help can be provided by Wyoming law enforcement. What does that look like as an example? For example, if there's a pickup full of fentanyl coming out of Denver, and the feds ask for help to detain that vehicle, even if a gun is involved, that's totally fine. It's spelled out right there in the bill. If an armed robbery suspect from Denver, I keep picking on Denver, I guess. If an armed robbery suspect is fleeing up and they need help to grab that person, even if a gun is involved, that's also permissible because that's a violation of Wyoming law as well as federal law. And there's a carve out clearly spelled out here for all felony persons crimes and narcotics crimes. Fifth, I've heard a lot of people claim this bill is a supremacy clause violation because we're telling the feds what they can and cannot do. That is simply not the case. This bill, nowhere does this bill tell the feds what they can and cannot do. It simply says that they cannot use Wyoming officers to help them with the enforcement of federal gun control laws. To go beyond that would perhaps be a supremacy clause violation. We have not gone beyond that with this legislation. We've heard an awful lot about the idea of this preventing all task force work. And that is absolutely not the case. If you look on page 3, line 14, through page 4, line 5, it clearly says the only task force that is prohibited are those that deal with confiscating firearms, ammunition, and accessories. And that means that all other task forces would not be impacted. U.S. Marshals Task Force, DEA Task Force, an ICE Task Force, the tribal task forces, all of these are permissible under this legislation. It only deals with, for example, an ATF task force whose purpose is to confiscate firearms, ammunition, and accessories. Lastly, Madam Chair, we've heard a lot in the last couple of days that this law is the same as the one that Missouri had struck down several years ago. This is not constitutional or legal. That is also not the case. This bill was drafted after the Missouri situation. It is different in its origins from the ground up to take into consideration what the courts said in the Eighth Circuit. This does not have a whole list of the things the previous law in that state had. And so it's definitely not going to be, it's definitely different from that bill from the ground up. Lastly, on page 7, line 13 through 14, and page 9, line 2 through 3, you'll see who SAPA does not protect. It does not protect felons. That's on page 9, line 2 through 3. It does not protect anybody who's not a resident of Wyoming. It does not protect those who are here illegally either. That's also on page 7, line 13 through 14. So anybody who says that, well, if we pass this, we can't aid in the deportation of illegal aliens, that's simply not the case, and the bill is very clear about that. As you heard from the bill sponsor, this bill passed your chamber last session, 53-7, and it passed the Senate chamber, the other chamber, 29-1. And we're again in full support of this. Happy to answer any questions.
Committee, are there any questions? Not seeing any. I guess I have one. What issue does this bill solve a problem that currently exists in our state?
Thank you, Madam Chairman. That's a very good question. We get that a lot. I would say that it could, but it is much more forward-looking. It is much more about the situation that could come down the road. I can't sit here and say for sure that there would never be a violation with the current law enforcement officers we have in Wyoming. I can't say that would never be a violation that would take place, but we're especially looking forward to the future to protect gun owners under the next administration. The previous administration tried to order in-state officers to enforce unconstitutional gun mandates, like a pistol brace ban, for example. And these things were never went through Congress. They were never actually admitted into law. They were orders signed by the president and then handed down to local law enforcement and said, here, go and enforce these. Now, that was struck down in the courts, thankfully, but that happened just in the last couple of years. And so we've had this problem in the past, and we're hoping to get ahead of that for the future.
Thank you. Thanks for your testimony.
Thank you, Madam Chair.
Are there others who would like to testify in this bill? Please come up, introduce yourself. Welcome.
Madam Chair, thank you. My name is Alan Thompson, the Executive Director of WASCOP, the Wyoming Association of Sheriffs and Chiefs of Police. And I think every member of the body and the other side of the building have received a letter from our membership indicating that the 23 sheriffs of the state of Wyoming and myriad chiefs of police are in opposition to this, and not because of the intent of the bill. I think it's clearly that the intent of the bill is, like with the testimony we heard earlier, that forward-looking component of it, and the concern with some sort of federal requirement or impact in the communities from our law-abiding citizens. The problem the law enforcement in Wyoming have is in the language in the bill and what it really means when our officers are in court. We provided a list of amendments that we hope that you will consider at least a little bit. I'm not sure that you've gotten them yet. They were provided to the LSO prior to the committee meeting. But I would just like to walk through those most important ones really quick. I mean, each of those things help delineate the intent of this and still protect law enforcement for things like errors and misunderstandings and so forth. But I would just draw your attention to page 6 there at the bottom, or all of page 6, I guess it is, in the House bill. I think that would be your subsection D of this. And this is where we talk about the task force considerations. I think we all have some testimony that dives into that a little bit more, but I think the intent is clear that we don't want gun specific task forces in Wyoming, but I think that adds additional liability concerns to administrators of law enforcement that would not hire otherwise qualified people. And it also diminishes their willingness to get involved in task forces, because the definition in there just says any, federal employee, person, agent, that type of thing. It doesn't delineate with firearm specific task forces. So the risk then is increased for the administrator by hiring those people or sending his people to that task force, then rotating them back. In 10 or 15 years now, we have 2/3 of the agency have met that definition. And I would say that that's unneeded, because the rest of the bill still prohibits all of those activities that you're looking to accomplish with this. And so all it does is add additional liability or an additional cause of action, to further confuse the issue. The overall general message of the bill is somewhat vague to law enforcement, and there's some preemption questions in there and so forth. But I'd also like to, we heard testimony that this doesn't prohibit law enforcement, federal law enforcement in any way, but it does call into question local law enforcement assisting federal law enforcement. So it lines out how we can assist them in gun-specific things. However, when they call in an emergency situation, our officers and deputies do not have the opportunity to find out what the crux of the issue is before responding in an emergency life-saving situation. So page 8, line 3, we've offered an amendment to try and clarify that. And then page 9, line 3, I think we want to really point out that definition of a law-abiding citizen. We all understand the intent of a law-abiding citizen. However, a person that is just committed a crime and is sitting in a jail cell right now and hasn't been convicted yet of a serious crime is technically a law-abiding citizen. So if you would consider adding some language into there that otherwise further defines that to help that investigation portion, something like is otherwise not engaged in felonious activities or criminal or unlawful activities or something to that effect. And we had the opportunity to talk about some of the amendments to clean up the civil interested party portion and move it into subsection D. We didn't offer an amendment on that language because our request is to still remove that subsection D. But I would ask you to consider, if that language stays the same, an interested party is a pretty wide open allowance for civil liability on law enforcement that they can't even contemplate. If we change that word to an injured party, that would, I think, better tie this into what the actual intent of the bill is. And I would just be happy to answer any questions. I think you'll hear some testimony that talks about specific issues from the people still working in the field. Thank you.
Thank you, Mr. Thompson. Are there any questions from the committee members? Representative Haroldson.
Thank you, Mrs. Chairwoman. So, Mr. Thompson, thanks for joining us today, and thank you to our law enforcement as well for being here. So I think it's been 5 years this bill's been playing around in this house. And I'm gonna be really blunt. I'm frustrated. I'm frustrated that we're 5 years in and we haven't gotten it figured out in the realm beforehand. Not day of, not when we're sitting in a committee trying to read in 10 lines worth of amendments, trying to figure out what it does to a bill. Like that's a frustration to me. Last year it passed with an overwhelming majority. I mentioned to you earlier, this bill, unless something very much surprising happens, is going to become law in the state of Wyoming. And what we want to do is support you guys as law enforcement in the state of Wyoming. But we also want to protect the rights of the people that are blowing up our emails and having these conversations. And so my frustration comes back to last year after that veto happened is when this conversation should have moved forward of contacting sponsors saying, hey, let's have these conversations so we can find this middle ground where we're not taking away rights and at the same time we're not turning around and hurting law enforcement. There is a lot of, well, it could be's in this that I'm seeing. And I don't disagree with you. It could be's, but I also understand the fact that what we've seen happen on the federal level, not recently, but in the past, is terrifying to us as law-abiding citizens and gun owners. When you sit there and go, well, we could very well lose our most precious right as Americans, the right that defends all other rights. And we could see this state be a part of that. Would they? We could say, oh no sheriff in the state of Wyoming would do that. We don't know that. And this gives the tools to make sure that doesn't become reality. And so my question really goes back to the question I've been asking over the last 24 hours is, what does this look like to have that conversation? And I'll be the first to admit, I struggle with, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 pages or line items worth of amendments to go into here that when we do one small change, it redirects courses of bills. And we now have 15 changes that are potential to this bill. And I know my frustration is showing, but one of the things that I've learned in the last 6 years is this process requires that conversation. So to the bringer of the bill, to you as well, we need to do better. And that's my frustration show.
Madam Chair, may I respond?
Yes, Mr. Thompson.
I'd just like to add that we did provide the crux of the amendments that I just mentioned today were also provided last year and weren't considered. And there's an existing statute in Wyoming that law enforcement in Wyoming does believe covers the concerns of this bill. So that's where we're at from the law enforcement side. Thank you.
We'll continue with public testimony. Who'd like to go next? Welcome, Sheriff.
There we go. Madam Chair, Representatives, I'm Sheriff Aaron Applehance of Albany County, and I'm here on behalf of WASCOP to just reiterate and hit home some of the things that Director Thompson said. Definitely in this bill, we understand the intent of the bill, but there's a certain reality that the intent of this bill does not match the language and how it's going to be enforced on there as well. So you guys have the letter, a joint statement from WASCOP signed by all 23 sheriffs. It's the sheriff in every single one of you guys' district, and a number of chiefs of police, and including the Highway Patrol, which will be providing testimony here shortly as well, that the bill that you have in its current form just simply does not work. There's tons of issues with it. I understand the frustration from Representative Haroldson in there, where if you have to provide 15 amendments to a bill, frankly speaking, it's probably not a good bill if you've got to change a lot of it just to make it work. Let me go through a few things on why this bill hasn't worked. You've heard some previous testimony that was also salacious in terms of how this bill works. But this bill, with the language that it's trying to add, does violate the supremacy clause. It's the same language that was introduced to a bill in Missouri in 2023 that was struck down by the 8th Circuit Court of Appeals. The only real difference of that bill and this bill would be if we were to move forward with it, it is probably going to be struck down in the 10th Circuit Court of Appeals as opposed to the 8th. So this really doesn't help law enforcement in any way, shape, or form in the quick decisions that we have to make in terms of enforcing the law, specifically enforcing gun laws. This introduces things for my deputies, officers across the state. It introduces a, how do I say it, indecision when it comes on if we can enforce the laws that are on the books or if we're violating state law. And in a lot of the investigations that we have, we don't necessarily have the time to sit down and do a deep dive into, is this going to increase the liability of our agencies? So a lot of things that we have to deal with are tense, rapid, uncertain, and we have to take the totality of the circumstances in there. This bill adds into that and really muddies the water. So this bill would take agency representatives, agency CEOs such as myself. It forces us to really take a look at our cooperation with our federal partners in every way, shape, or form. For every federal partner, the reality of it is when you have your boots on the ground, not every case or investigation that we get is solely black and white, a firearms a violation. A lot of the times they're mixed in, or you go to a call where it ends up being one thing and then it turns out to be another. So this bill doesn't allow kind of the reality and that leeway for us to do our job. So this opens up law enforcement and local governments to civil liability claims by anybody. Make no mistake, in this bill, it does not differentiate who can and who cannot bring a liability claim against the agency or the municipality, town, county, whoever it'll be. It really just says in there very specifically party or interested party in there. There's also lines in there that it removes our sovereign immunity. So sovereign immunity is not a claim for defense, providing no legal means for law enforcement for us to defend ourselves legally on there. And so I know that there were claims that were made earlier that this isn't going to involve individual officers having claims being brought to them, but it removes that sovereign ability. And so, yes, that opens up that liability for claims, not only to be brought against, like I said, the government or, like I said, county, municipal, but then it does open that up specifically at that federal level for individual claims. So you heard testimony that also says that this doesn't allow, that this allows law enforcement to continue their cooperation with the federal government and the many agencies that they have. There's a large section in there that defines what material aid cannot be provided to federal agencies in enforcement of this bill. Basically says no funds or material aid, which includes but not included everything of facilities, personnel, physical assets, communications. It even goes far to say social media. It really just has everything underneath the sun except medicine and life-saving care in there as well. And so there's basically says one thing in the bill and then says another thing in the bill where it says you can cooperate, but you can't cooperate by providing them essentially anything in any way, shape, or form, unless you're attending to somebody that's in a medical emergency situation. So it really ties our hands, handcuffs law enforcement in there as well. Law enforcement brought these concerns last year. to the committee, and to the entirety, of the legislature. And it, like you guys have said before, it passed, not taking those concerns under consideration. Today, I will let you know that, like you said, this is the testimony that you're going to get from your law enforcement experts in your district. So you're not going to receive a whole lot of other testimony from people that are boots on the ground, from your law enforcement experts here in the state of Wyoming that work every day, to help public safety, to enforce those laws, and to make sure that the rights of our citizens are being adhered to. So, like I said, you have that letter with all of our signatures in there, and we hope that that's a signal to this committee and to the body as a whole of how your law enforcement views this bill. And we view it as problematic, and it's going to be very difficult for us to maintain the relationships and the current level of law enforcement here in the state moving forward.
Thank you, Sheriff Appelhans. Are there questions from the committee? Chair Bear.
Thank you, Madam Chairman. Thank you for being here, Sheriff Appelhans. In your time here in the state of Wyoming, how many times have you seen a case where you were working with the federal government and whatever the charges were that you were going after, they fell apart, whatever happened, and it turned out that the gun charge was the one that you could go ahead and convict on? Have you seen that happen? And if
Yeah.
so, how often does that happen?
Sheriff.
Oh.
Through the chairwoman, thank you.
Sorry, excuse me. We actually see it a lot in our task force operations that we have, where we'll have a lot of local charges, but for a variety of different reasons, those local charges are going to be extremely difficult to move through that court system. But then there's a federal firearms charge in there that is much easier to move through the federal courts on there. And so we do see that quite a bit. And like I said before, those aren't just on cases involving firearms. A lot of the times those cases start out most of the time as a drug charge on there as well. And so, and then there's a violation that moves up into a firearms violation. So we've also seen the reverse happen a few times as well, where the task force will go out and make a series of arrests on there as well. And based on the investigation, the information that we have doesn't necessarily meet that federal charge, but meets a state charge on there as well. The way this bill is currently written on there, like I said, it brings into question if we're able to continue that practice, either moving charges up to the federal level or moving charges down to the federal level. And like I said, I'm kind of telling you as a sheriff as well. Like I said, if this goes through, I have to take into account a lot of things, and most likely it's going to force me to start to remove people from those federal task force so that we're not in violation of this law.
Mr. Chairman, do you have follow-up?
I do. Thank you, Madam Chairman. Sheriff Appelhans, you stated that you felt like this opened up the liability to the individual officers. Can you explain to me how you think that happens in this particular bill?
Yes. So if there's a violation, like I said, in this bill, it says sovereign immunity is not a claim for defense. Very clear line in this bill. Removing that, if anybody is to go ahead and make that claim, just to give you an example, let's say somebody were to make a claim against my sheriff's office there, that claim is not going to be litigated in either circuit or district court. Because of where I am in the government, that is going to be a claim that's already going to get bound up to a federal court on there. And so removing that sovereign immunity in there is somewhat close to removing that qualified qualified immunity, which would be a question that would come to that federal court in there also. And so under the color of law in a 1983 suit on there as well, you have the ability within a certain time frame to not only make claims against the government or the agency, but against the officer, either in their individual or official capacity or both.
Can you quote, I'm sorry, Madam Chairman, can you quote that again? That where
It's
is that?
a color of law 1983 claim, the federal level.
Mr. Chairman, do you have further follow-up?
I'll let the committee continue or go to your next.
Representative Pendergraft, did you have a question?
Thank you, Madam Chair. I believe this is your proposed amendments, and I think I already know the answer to this question, but I'm going to ask it. If we made every correction, every amendment that you have listed here, would you look on this as a good bill? Would you be in favor of the bill, or would you just merely find it more palatable?
If we were, Madam Chair, if I may.
Thank you, Sheriff.
Sorry. If we were to make every single amendment and you guys were to take into account all of the recommendations that we've made at this testimony, it would make it more palatable. I think there would still be some questions from our, representing our agencies, if we could still move forward with the level of law enforcement that we have here in the state. But we offer those amendments so that we can kind of move towards that. The history of this bill is, at least from my perspective, there's been a lack of cooperation from the authors of this bill, the debate of the body, with law enforcement in there. And so we really wanted to take this time to try and move forward together. Because like I said, we understand the intent of the bill. And many of us have the same sentiments with the intent of the bill. But the reality of the bill is that in its current form, it is not going to meet the intent in there. And if anything, it'll do the opposite.
Follow-up?
Thank you, Madam Chair. And thank you for that answer. I appreciate the honesty. The only way that we can ever get through Representative Haraldson's frustration, indeed my frustration, is with open and honest communication. And so I guess my question is, do you think that there is just a fundamental disagreement about law enforcement between those of you, and it's quite impressive, the list of people we got there, and those of us sitting on the outside? Do you think there's just a fundamental misunderstanding? I'll leave it at that.
Sheriff Alphonse?
Yes, Madam Chair. To answer your question, Representative Pendergraft, I do think that there's a fundamental miscommunication on how we go about do that. Your law enforcement here in the state work very hard every day to not only provide the public safety that we're sworn to provide, but uphold the rights of our citizens as well. Every single sheriff and chief that is signed on this is a pro Second Amendment sheriff or chief on there. The last thing that we want to do is violate the rights of our constituents on there as well. And so, like I said, I think that there is a miscommunication because we are trying to communicate to you guys that we can still uphold those rights. We can still do the law enforcement that we're sworn to do here in the state without this bill and do it at an extremely high level. So,
Representative Pendergraft?
Thank you, and thank you for your patience. I'm really trying to make this work, and I want to see it work for law enforcement. I want to see it work for those of us that are concerned with the issue underlying this bill. So, has it ever? You have stated that you understand and agree with the underlying principle that we're trying to get at. Have you and your associates ever attempted to say, write a bill yourself and say, this is what it should look like, rather than simply trying to alter
Mhm.
each offer that we make.
Sheriff Appelhans?
Yes, we have. A lot of the times the bills that you guys have come down on there, we really work behind the scenes to tell you that you need to change kind of one word here. This is what's going to make it legal. This is what's going to help us out. We go through that process all the time on there as well. In the Second Amendment Preservation Act, we tried to do that as well, where we offered an amendment last year, a much shorter version of this bill to be able to make it work. So, but that amendment unfortunately was not introduced in there, and so we're left with what we have here. So I do believe that there is a solution to this bill. I will be honest with you, since we're having an honest conversation. The solution for what's currently written here is almost a complete rewrite. So a lot of the amendments that we have changes that legal language in there. The things that we've talked about is removing complete sections out of here that doesn't work for law enforcement. And so I think that's at the point where we're at, to be honest with you.
Representative Pendergraph, a follow-up?
I think that follow-up was supposed to have been the last. Would you be willing to offer that bill?
Sheriff Appelhans?
Madam Chair. Yes, I think we could work together to offer a bill that meets that intent without all of the unintended consequences that we see coming immediately from the current bill that we have here.
Thank you, committee, for the thoughtful questions. Representative Haroldson, do you have a question?
Yeah, thank you, Madam Chairwoman, and Sheriff, thank you for joining us today and having this conversation. So one of the things I think I do want to look at, and I guess I'm going to go back into my statement that I made earlier. One of the things that we're seeing is kind of a bit of a tone deafness to when we see, I mean, if it was a deal where it passed the House 32 to 30 and we squeezed it by, but when you got massive veto-proof majorities passing legislation, when we've got a bevy of attorneys it goes through constitutional checks and muster checks and all of those things, and we get bill drafts that go forward. What I stand here saying is I agree with everything that's being said, but I think there's also that frustration of going, okay, well, do we throw this down and say maybe next year? And what happens if one person, and I'm not coming out against our law enforcement. I have massive amounts of respect for what you guys do, massive amounts of respect. But what happens if someone loses their rights? What happens if someone turns around and gets themselves into a position where there is a bad actor? Because this is it. Let's face it. There's bad actors in every sector. We all know that, right, guys? And we could look back and go, well, we were waiting to try figure something out. And I would say that my challenge is this. I mean, if you look at the co-sponsor list, this bill's moving forward today, folks. So what that means is now it's time for definite, clear action. And we've already started these conversations. We'll continue these conversations. Definite, clear action from your guys' body with the sponsor of the bill, with our gun groups to say, hey, let's really look at this. And I also don't want, well, the sky is falling mentality where we're just going to eliminate the protection at the same time. Don't you think?
Madam Chair, if I can respond.
Sheriff Appelhans?
Representative Haroldson, I agree with your frustration and the tone deafness that you said. The law enforcement has come to you guys also with our legal representatives, both at that state level and in this year in consultation with some of our law enforcement and legal representation at the federal level as well, to bring these concerns to you guys as well. And so I do agree with you that there needs to be actionable items to make this bill move forward. And we have brought those to this body on what those actionable items are, and have testified today as to what those actionable items are so that we could maintain those protections. And we still are able to maintain those protections with the laws that we do have on the books. The state of Wyoming has a variety of different firearms laws that are very favorable to the citizen in terms of maintaining their rights. We don't disagree with that in any way, shape, or form. And even with a bad actor, one bad actor that comes out, we feel that we're still able to do our jobs and maintain that high level of both state and United States constitutional protections for our citizens. And so, like I said, I agree with your frustrations and I understand where you come. We have maybe a little bit different way of getting there. Like I said, those action items have been presented to you guys. Like I said, we look forward for this body, if you are going to move this bill forward, to take those under high consideration so that we can make this work for all.
Thank you, committee. I think just out of respect for those who are here to offer public testimony, we will move on. Thank you, Sheriff, for being here.
Thank you.
And would welcome our next speaker.
Good afternoon, Madam Chair, members of the committee. My name is Carl Germain. I'm the Lieutenant Colonel with the Wyoming Highway Patrol. I want to express how House Bill 130, as currently drafted, could negatively affect the Wyoming Highway Patrol's ability to fulfill its duties and maintain effective partnerships. The bill appears to prohibit the enforcement of any federal firearm regulation, including penalties for violations and restrictions related to cooperation with federal authorities. The language as written creates significant operational and personnel challenges for state law enforcement, including the following: restriction on participation in federal task force. The bill, specifically subsection D, would limit or prevent Wyoming state troopers from participating in federal law enforcement task forces, including but not limiting to 287G program. That's Immigration, Customs, and Enforcement, ICE. We currently have approximately 12 troopers that are assigned to that task force. They go through extensive training to become an ICE agent or have the same arresting authority as an ICE agent under the umbrella of ICE. That allows our troopers to enforce immigration and custom laws in the state of Wyoming and apprehend people that are here illegally if they fall within that jurisdiction. Oftentimes, it's not always black and white. You could have someone that they're arresting that's here for an illegal status, and in the course of that arrest, they come across a gun charge, and since they're the operating federal agent, they're going to be the person who's bringing forward those charges with ICE. Recently,
I'm gonna pause just for a second. Committee, I just want to ask everyone, because the audio in the room can be challenging. Can everyone still hear okay? I want to make sure we're able to focus on the testimony. We love that there are people exercising their rights behind us, but committee members, are you still able to hear the testimony? Kind of? Could you pull the mic just a little closer? I appreciate that, and I apologize for interrupting you. Please continue.
Madam Chair, no worries, and I can also speak louder. Thank you. Recently in Rock Springs, we had Border Patrol Commander Bavino had stopped by, spent the night in a protest somewhat erupted where we were called to assist Rock Springs PD. Given should this law pass, I would be hesitant to order troopers to go assist federal agents in those types of situations, just given the fact that we don't know what kind of gun laws could present themselves, or gun violations. In the Wyoming Highway Patrol, we also have a good partnership with the reservations that are within this state. And we have officers assigned to the Bureau of Indian Affairs Task Force. Those officers also go through extensive training to become a certified BIA agent. That allows Wyoming state troopers to enforce federal laws against tribe members where they otherwise would not be able to. I was a commander in the area that served over the reservation for 3 years, and during my tenure as a commander in that region, I can attest to numerous occasions where we had Wyoming state troopers unable to take enforcement activity against a tribe member that was intoxicated or committing other crimes and had to wait on the side of the road for hours until a BIA officer could arrive. Sometimes BIA was not available and we had to make other arrangements, such as a family member or friend coming to pick up an intoxicated driver. During the course of those arrests or law enforcement encounters, if they're operating with BIA authority, they can use federal statutes to enforce laws. And you could come across a Wyoming citizen that is also a member of the tribe that is committing a federal gun law, and we would be in violation of this bill should it pass. We also have troopers that serve in the U.S. Marshal Service. They go around at times apprehending violent criminals. Some of those criminals have committed federal gun laws and are citizens of the state of Wyoming. We have troopers assigned to Homeland and Security Investigation, HSI Task Force. Those troopers assist with human trafficking and narcotic investigations. Oftentimes, our federal partners are stretched thin, and this gives our troopers the ability to operate in a federal capacity, and at times during those investigations could enforce a federal gun law or any other joint federal, state, or multi-agency law enforcement initiative. Recently, we sent 10 troopers to the state of Texas to assist them with immigration, customs, and enforcement of their border. This limitation stems from the potential that such participation could involve enforcement of federal firearm-related charges, even incidentally. And as a result, as the operations commander of the Wyoming Highway Patrol, it would be my recommendation that we remove our troopers from all of these task forces, given the fact that the fines associated with them going out doing their job would be detrimental to our budget. It would also lead to indecision by our officers, putting them in harm's way. 3, prohibition on hiring or employing individuals with prior federal firearm enforcement experience. This bill's restrictions could bar the Wyoming Highway Patrol from hiring or retaining any person who has previously enforced federal firearm laws in any capacity. This would severely limit our recruiting pool and could disqualify qualified candidates with valuable federal experience, including those that served on prior federal task force, prior federal agents, and possibly even military veterans if they enforce federal firearm laws while serving in their capacity as a member of the armed service. These provisions could undermine critical public safety partnerships, reduce our effectiveness in addressing interstate crime, drug trafficking, human smuggling, immigration enforcement, and other threats that often require federal cooperation and create unnecessary administrative burdens. Thank you for your attention in this matter, and I'll be happy to stand for any questions, Madam Chair.
Thank you. Are there any questions from the committee? Mr. Chairman?
Thank you, Madam Chairman. Trooper Jermaine, thank you for being here. Appreciate your testimony. You gave a couple of scenarios there, but isn't it true that in the case of this statute here and in its enforcement and your concerns, that if you were to send your troopers to that situation to assist the local police to protect those ICE agents, not knowing what you're going to run into, that it really comes, and then they were to find a firearms charge, then it would really be up to the prosecutor, and they would be able to weigh out whether there's a liability to your agency for sending them there based on this statute or not, as to whether, they feel like there's a violation of this statute and at the same time a violation of a federal gun law that maybe they were arrested on. Is that possible, the way that that scenario would work out without you, when you're making the decision to send the troopers there, not knowing? I understand you can't possibly know everything that you're going to run into when you send people out. But when I look at this, it seems to me like the prosecutor would have some time to contemplate all the possibilities and decide whether they're going to prosecute that federal gun charge or not. If it's going to create more liability for your agency, they'd weigh those things out. Is that a reasonable scenario, a reasonable way of interpreting this law, this statute?
Mr. Trubain?
Madam Chair, Representative Bear, thank you for your question. It's always up to the prosecutor whether or not charges are going to be brought forward. So in that fact, your explanation would be true. I feel the problem is that we oftentimes are relying on that trooper to provide testimony, to be able to provide the probable cause for that arrest. And if it's solely a gun charge, there's a potential that are we or are we not in violation of this state statute? And I just brought up that example because it was one that happened recently and involved federal agents, and thankfully nothing happened, but it creates indecision in our decision-making ability to go and back up our federal partners.
Thank you, committee. Are there other further questions? Thank you for being with us today. Appreciate
you,
your
Madam Chair.
testimony. Please welcome.
Thank you, Madam Chairwoman, excuse me, and committee. My name is Mark Jones, and I'm a National Director with Gun Owners of America. I live in Johnson County, Wyoming. And I'm here today to support this bill. And someone made an earlier comment about how that this has been going on for many years. This is at least the 5th legislative session that I've worked on this bill. As it was introduced last year, we had some problems with it because it removed the criminal penalty that was put into statute in 2022. And as the process went through the legislature last year, as this bill was amended, we ultimately ended up supporting it and were quite disappointed that the governor vetoed it. So what you essentially have here is a bill that passed last year with 83 members out of 93 members voting for it. And I think 5 or 6 were excused. There were only 4 or 5 people in the entire legislature that voted against this bill last year. And I wasn't planning to bring this up in my testimony, but since Representative Harrelson and Representative Pendergraph indicated some frustration with communication processes, I want to point out that I have consistently reached out to the law enforcement community for 5 years. I have had multiple meetings with the Wyoming Association of Sheriffs and Chiefs of Police and the Wyoming sheriffs. Many of them took place at the Law Enforcement Center in Buffalo, Wyoming, where I met with anybody who was willing to come. Those meetings were attended by senators, by representatives from the House here in this chamber, and by representatives of our law enforcement community. My door has been wide open for working with anybody on the Second Amendment Protection Act. So I'm a little frustrated too at some of the amendments and the accusations that have been made today. When I heard about some of these comments that were being made about this bill, I called some of our attorneys prior to your adjournment, and I have access to attorneys that argue in front of the United States Supreme Court. I'm like, what about these claims? And I tell you, we couldn't be further apart about the claims that this bill stops immigration enforcement, ICE enforcement, and some of these other claims. I don't know that they're founded in legal reality. So where's the discussion been about this for the last 5 years? This bill does not stop law enforcement from doing many of the things that have been testified to today. Stops participation in federal firearms related activities. They can participate in ICE activities. It's illegal to enter this country illegally. Okay? And if there's evidence found of a crime that's a crime in Wyoming, they can enforce that as well. So I think there's a lot of miscommunication, but I think some of the accusations that have been made are a little bit over the top. We support the bill. We do think it, and it sounds fairly minor in the grand scheme of things, given the discussions that have took place today, but we do think some of the definitions of firearms accessories need to be cleaned up. They're not well defined. I've sent that language to Representative Bear, Representative Harrelson, and Representative Pendergraph to just clean up the definition of firearms and firearm components so that there are no questions or loopholes. But that's a fairly minor thing, I think, that can be fixed. Otherwise, we support the bill, the concepts in the bill that allow a citizen to go to civil court and sue the department if their rights are violated. And I want to, as it's already been pointed out, civil lawsuits will be against the department, not against individuals. It's not going to do away with qualified immunity and allow people to sue officers. That's not going to happen. And the criminal penalty that's been in statute since 2022 remains in here, which is very important. I'll also point out my organization is a staunch supporter of law enforcement at the national and state level. We always have been. But this law is designed to protect Wyoming citizens while allowing law enforcement to do their jobs. So with that, I'll stand for any questions.
Committee, are there any questions for Mr. Jones? Mr. Chair Bear.
Thank you, Madam Chairwoman. Couple of things. I don't want to go too back historically, but I did hear you say that you don't believe that qualified immunity would be eliminated for an individual peace officer based on, I assume that's based on the language that is currently on page 6, lines 1 through 3.
Yeah. The bill, as I understand it, sorry, Madam Chairwoman.
Thank you.
Mr. Chairman, Representative Bear, sorry. As I understand it, the bill waives sovereign immunity for the department so that an individual can sue the department. It does not, and it's my understanding this bill does not allow an individual officer to be sued. And there's a big difference between sovereign and qualified immunity. Sovereign immunity is the department's immunity. So any lawsuits would be filed against the department, and any damages or any payments would be paid from the department budget. We worked very hard for 5 years to ensure that the monetary threat would be against the department rather than the individual officer in order to be friendly to law enforcement and protect officers. But if you have a sheriff, and I'm not saying we have any in Wyoming, but there's 4,000 sheriffs in America. If you have a sheriff that doesn't respect the Second Amendment, this would be a threat against the budget of their department.
Well, thank you, Madam Chair. I'm sorry to take more time, but when I'm looking at this, I'm looking on page 5, and it clearly states that the penalty, the civil penalty, does apply to an agency. It doesn't say anything about a law enforcement person like a police officer, a peace officer. But then it does say on page 6, when it is eliminating the sovereign immunity, and I assume that the definition of sovereign immunity is different from qualified immunity, but it does apply language here that it shall not be an affirmative defense. So the difference between the definition of sovereign immunity and qualified immunity, do you see this language addressing sovereign immunity opening up the potential for qualified immunity if this were to be addressed in a court of law?
Mr. Jones.
Madam Chairwoman, Representative Bear, in my understanding, and again, I'm not an attorney, but I have access to attorneys who review these bills, and is that this only opens up the departments for lawsuits, not the individuals. Now, a citizen can sue for anything. That doesn't mean they will be successful. And anything, I mean, non-firearms related, I can sue you because I don't like the color of your red jacket. And I'll probably lose and waste a lot of attorney fees. But no, my understanding is this does not open up an individual officer to a personal lawsuit. This only makes the departments liable. And again, it's a steep hill for a plaintiff to climb to hire an attorney and go to court and actually prove this against a department. This is not easy to do. We have citizens right now that feel their rights have been aggrieved. There's been one lawsuit filed in this state that's in process right now. And it took the citizens 2 years to raise the money to file that, to go to court in a civil process against the department. So it's not going to open the floodgates to lawsuits. And it's a very steep hill to climb, and it's against the department rather than the individual. Madam Chairman.
Mr. Chairman, follow up and then Representative Haroldson.
Thank you, Madam Chairman. Thank you for the response. You did answer my question. I don't like my red jacket either. But I said I was going to try not to get into the history, but I do want to ask you a question historically. I know you brought the original Second Amendment Protection Act in 2022. Your organization kind of authored that with the bringers of the bill. And prior to that, there was a similar letter from 23 sheriffs not wanting to go down this path that we are here, where we're offering an opportunity for the individual to sue, that civil liability. Why did you not bring a bill with civil liability already in it back in 2022?
Mr. Jones.
Madam Chair, Representative Bayer, great question. We could stay here probably all night and talk about the history of the Second Amendment Protection Act in Wyoming. There have been multiple attempts at this. Multiple groups have worked on it. Some have agreed, some have disagreed. We have brought bills in the last 5 years that did have a civil process, though there have been more than I can remember. Many did not make introduction. So this has been an ongoing process. As I said, I have met multiple times with representatives of the Wyoming Association of Sheriffs and Chiefs of Police and members of this legislative body to try to figure out a path forward. And our organization's position has always been that we have to have two things in a Second Amendment Protection Act. We have to have a criminal penalty that is enforced by the county prosecutors against an individual officer who violates their oath to the Constitution, essentially. We have that now in Wyoming statute, and we have for 4 years. And we have to have a civil process where a citizen can go to court and sue the department. And we've always been very careful to say, we want a citizen to be able to sue the department and hurt the department's budget. We do not want the citizens to sue individual officers. We're very pro-law enforcement. We don't want an officer to feel like they can't do their job. But sheriffs and leaders, they understand what is constitutional and not, and their departments understand it. So we've been very consistent for years in trying to get both of these processes. And they have failed for different reasons in the past. Legislative composition changes every 2 years. And this is almost in some ways the culmination of many years of work with different groups that sometimes they don't agree on everything, but sometimes they do agree. And this is the culmination of years of work involving multiple organizations, multiple groups, and actually multiple legislatures, because some of you guys weren't here when this started. Some of you are new, some different people were here in the past. And again, this bill I think there were only 5 people voted against it last year in both chambers, 5 or 6. So it's a culmination of a lot of years of work.
Mr. Chairman has one more follow-up.
Thank you, Madam Chairman. We're going to have to wrap this up quickly, so I apologize for another question. But do we not have, didn't we already broach this civil penalty issue when we did the red flag law a couple of years ago?
Mr. Jones.
Madam Chairwoman, Mr. Baer. Yeah, the red flag law only applies to red flags. This applies to any Second Amendment, any way in which your Second Amendment rights could be violated. For example, enforcement of an AR-15 ban, enforcement of a magazine ban. So this is important to close all the loopholes in Wyoming in terms of Second Amendment rights protection.
Representative Haroldson.
Thank you, Madam Chairwoman. Just real quick, if you go on to page 8 line 17 through 19, well, 11, it says nothing in this section shall be construed to, and then 17 through 19, it says impose liability for civil penalties under this section on individual public officers or peace officers. So it's directly stated in there that this is not applying to qualified immunity. It's not taking that away.
Thank you. Is there, so I want to just, we have to gavel back in at 2:30. Is there anyone else who would like to testify on this bill?
Thank you, Madam Chairwoman. Thank you, committee.
Is there anyone online?
We do have a Travis, yes, Koltiska, and I'll add him in now.
Welcome, Mr. Koltiska. When you are ready, we're ready to hear your testimony. Welcome.
All right, we're gonna try this one more time. Can I be heard now?
Yes, we can hear you. Please go ahead.
Okay, thank you, Madam Chair. My name is Travis Koltiska, and I serve as the Chief of Police of the Sheridan Police Department. I'm here today to discuss the potential impacts that House Bill 130 would have on law enforcement operations in the state. You've heard from a couple of my colleagues already. I won't rehash that, but would like to provide a real life scenario. Today's a little difficult. Today marks the 2-year anniversary of a tragedy that deeply affected my department and our community. On February 13th, 2024, a beloved husband, father, Army veteran, and sergeant of my department was murdered in the line of duty. The individual responsible for his death was a prohibited person, barred from possessing firearms under both federal law and prior Wyoming convictions. In the aftermath of that tragedy, the Wyoming Division of Criminal Investigation led an extensive investigation alongside federal partners, including the FBI and the Bureau of Alcohol, Tobacco, Firearms, and Explosives. One of the central questions was how the prohibited person was able to obtain multiple firearms, including the weapon used to kill our officer. This type of investigation requires specialized resources, legal authorities, and interstate coordination that are often beyond the capabilities of local and state law enforcement alone. That is why cooperation with our federal partners is not optional, it's essential. Through that joint effort, investigators determined that the firearm used to commit the murder had been provided by the suspect's own mother. She has since been prosecuted in federal court, convicted, and is now serving time in a federal prison for knowingly providing a firearm to a prohibited person. At the time of the investigation, under this current language of the House bill, that individual may have been considered a law-abiding citizen. And since this investigation had branched off, that investigation into her activities were focused solely on a gun crime, a violation of federal law. Law enforcement agencies in the state would have been prohibited potentially from providing any material aid to the ATF or the FBI, which included sharing investigative information, evidence, and the work that was done side by side. In practical terms, that means the person who knowingly armed the killer may never have been held accountable. The loss in Nevada, and I apologize for using his name, devastated our department, our community, and our state. It made a wife a widow, left a young daughter without her father, took a son from his mother. He was not only a dedicated public servant, but a husband, a father, and a friend. Holding accountable the person who placed the gun into the killer's hands was not a small matter to us or anyone in my community. It was essential to justice, to healing, and to public safety. In my 31 years, I have always been a strong supporter of the Second Amendment and the right of law-abiding citizens to keep and bear arms. That commitment has not and will not ever change, and it is shared by law enforcement officers across this state. But with that right comes a responsibility, and that's to ensure that individuals who have lost their rights through violent criminal conduct are prevented from accessing weapons. To do that effectively, we must retain the ability to work with all available partners, including federal agencies. I fear House Bill 130 would significantly restrict that ability and would create real-world consequences for public safety, for officer safety, and for justice. For those reasons, I respectfully urge you to carefully consider the operational impacts this legislation would have on law enforcement's ability to protect our communities. Thank you for listening. I'd be happy to answer any questions.
Mr. Koltiska, thank you so much for being with us today, for sharing your story, and know that yourself, your colleagues, the individuals in your community that have been impacted by this are in our minds right now. Committee, are there any questions? Representative Pendergraph.
Thank you, Madam Chairman. Thank you, sir, for being here with us. I just wanted to say that I appreciate your being here. I appreciate your testimony. I look forward to talking to you personally, face to face. I also wanted to mention for the record that we did have a moment of silence this morning in our opening ceremonies for Officer Krinky. And just needed to say that. Thanks.
Thank you, committee. Are there other questions? Not seeing any. And do we have anyone else online with us today?
No, Madam Chair, that's it.
Thank you again, Mr. Koltiska. With that, I will close public comment. And committee, what is your pleasure? The motion has been brought by Representative Haroldson, seconded by Chairman Bear. Committee, let's go through the bill page by page. Let me know if there are any changes. We're on page 1. Page 2. Page 3. Page 4. Representative Haroldson.
Actually, Madam Chairwoman, it's on page 5 that we're going to be making, or I'm going to be proposing an amendment. Line 17 through 22 on page 5. This language is in the wrong section of this bill, and what it really would honestly say is it opens up that civil action to anyone who feels that there's been a wrong done. In this situation, that could mean someone reads a news article about a seizure of a firearm and they think, man, wrong's been done, and they could bring a case. That's not the right place. So my amendment would be to remove line 17 through 21 off of page 5 and then reinsert that same language below line 22 on page 7.
Is there a second? Seconded by Representative Pendergraph. Committee, are you ready to vote on the amendment? All those who are in favor, please say aye.
Aye.
Opposed? That amendment carries. Is there anything else on page 5? Not seeing any. We're on page 6. Page 7. Page 8. Page 9. Committee, are there any other amendments? Not seeing any. We are ready to vote on the bill.
Roll.
Ms. Childress, could you take the roll?
Roll call vote.
Mr. Chairman, please.
Minutes across the committee. So thank you, Madam Chairman. I just want to say that I understand the concerns of law enforcement, and I've heard your concerns. I'm not convinced that there's an issue with qualified immunity. It seems to me sovereign immunity is pretty well defined here and limited to just the agency. I think the good Speaker Pro Tem's amendment cleaned up a lot of the issue. And my opinion is that the concerns about law enforcement not being able to have confidence to go into a task force situation is probably unwarranted. It really boils down to what are the prosecutors going to do? And I think we need to always be working on a relationship with the prosecutors, and the prosecutors need to be well aware of this law if it passes, and take that into account before they pursue federal or state gun charges, but definitely federal based on the way this is written. So I think that there's some risk here, but it's probably well worth taking to protect the citizens' Second Amendment rights.
Are there any other closing comments? Representative Pendergraph.
Thank you. I'll be quick. I appreciate the amendment concepts that were brought, and I will personally be looking at them very carefully and would have an opportunity to bring any on the floor.
Thank you. I think we're ready for roll call now.
Roll call vote, House Bill 130 do pass as amended. Representative Allemand?
Aye.
Representative Angelos?
Aye.
Representative Haroldson?
Aye.
Representative Pendergraft?
Aye.
Representative Sherwood?
No.
Representative Smith?
Aye.
Chairman Bear?
Aye.
Madam Chair, 6 aye, 1 no. And who would you like to carry on the floor? Carry this bill on the floor?
Representative Harold. Oh, Wharf. Oh, thank you. Thank you, sir. Committee, do you want to continue with one more bill in the next 10 minutes, or should we head to the floor and finish presenting the budget? Mr. Chairman, love your feedback on this.
Referral done. This would be a good time. We've got witnesses here.
Mr. Chairman, are you referring to House Bill number 52 or House Bill 66?
It's the water bill.
The water. It's the water bill, and we will hand it out right now. And it is House Bill, which one? 87.
Thank you, committee. We'll be working House Bill 87. This is a re-referral. Welcome, Director. If you'd like to present this to us.
We're not gonna have time to go through all this.
Thank you, Madam Chair. I appreciate the opportunity. So just real quick, this bill simply appropriates funds already in the water development accounts from mineral severance taxes and provides authority to the Water Development Commission to complete the studies. It's been vetted quite heavily through the Water Development Commission and the Select Water Committee, as well as House Ag yesterday. I'm just going to run through this real quick. If we open up to the front page, we have a summary sheet. It's a blue sheet. The first section of the bill is the Account 1 new development projects. We have 8 municipal master plans and the UW water research projects, and that equates to $2,186,997. The second section of the bill are our level 2 studies under Account 1. We have one of those for $327,000. We then have the third section, which is our rehabilitation account or level 1 studies. We have one of those for $470,000. The fourth section of the bill is the rehabilitation account again, but level 2 studies, which we have 2 of that equate to $528,000. And then we have funding for the Office of Water Programs, which administers the water research projects. And then the last thing in the bill is some additional funding and an amendment to the Nowood River Storage Project. And with that, I would ask if there are any questions.
Thank you. Committee, are there any questions on this bill? Not seeing anyone. Is there, do we have public comment? Is there anyone online who'd like to testify on this bill?
No, Madam Chair.
Committee. Representative Harrelson.
We got like 2 minutes. We're going to use it. Thank you, Madam Chairwoman and Director. Thanks for being here. And as we talk about this, really, we look at our snowpacks across the state. I mean, it's kind of a dire place right now in water world. But can you talk to me just a little bit as you're seeing this low time in the realm of water supply? Sometimes that's a great time for doing major maintenance and trying to kind of recover some of these assets that may be a little worn down. Can you talk just real quick? I know you don't have long, but can you talk a little bit about that concept?
Madam Chair, Representative Haroldson, are you referring to reservoir projects in particular, or just projects in general? So because of low snowpack, really that would potentially impact mostly storage projects, I would say. Everything else is associated with diversions, direct diversions, surface flow diversions, We're still going to have a spring runoff of some sort. Of course, the west half of the state is looking much better than the eastern half of the state. Most of those projects that we would complete as far as irrigation diversion type structures would be done in the fall, especially for irrigation outside the irrigation season. Reservoir projects, typically you're going to have minimum pools associated with those. Again, late fall, if they're irrigation projects, we're going to be drawing those down this year. Like every year, fall is going to be our best opportunities. As far as recovering sediment, accumulation, things like that, just because we're in a drought this year and have been for a number of years, that's not going to help that situation. Really, it looks at enlargements. Dredging is not very economical in that situation. So enlarging to recover sediment or storage loss to sediment, but not a great answer to your question, but it was a fairly broad question. So.
Committee, are there other questions? Not seeing any, I will move to close public testimony. And committee, what is your pleasure? Move to pass. We have first and second. Mr. Childers, could you do roll call?
Roll call vote, House Bill 87 do pass. Representative Alaman voted aye via absentee. Representative Angelos? Aye. Representative Haroldson?
Aye.
Representative Pendergraft?
Aye.
Representative Sherwood?
Aye.
Representative Smith?
Aye.
Chairman Bear?
Aye.
Madam Chair, you have 7 ayes.
Thank you, committee. With that, we need to head back to the floor. So I'm gonna, apologies.
Can you announce to the public what will happen with the bills that you have not considered at noon?
Yes, my understanding is that we will be meeting upon adjournment. We will be hearing House Bill 95, concealed carry, college and universities, House Bill 96, carrying of concealed weapons, age requirement, House Bill 97, Second Amendment Financial Privacy Act amendments, and if we have time, House Bill 66, which has been re-referred to this committee. Thank you, and we are adjourned.